Hello, everyone. Can you please quiet down a little bit? Hello. Good morning or afternoon. Thank you, everyone, for being here today. Welcome to the Asian American Law Journal's annual symposium titled Let's Get Going, Lessons from the Young Lawyers Who Overturned Korematsu, Hirabayashi, and Yasui. Our team decided on the title Let's Get Going in honor of the first memo of the same name that Dale Manami sent to the legal teams who took on the quorum notice cases. Many of those lawyers are present here in the audience today. I would like to recognize those present. So if your name is called, please stand. Eric Yamamoto. Lei-Ann Miyamoto. Karen Tsai. Rod Kawakami. Richard Ralston. Nelly Alvarez. Karen Sakamoto. Karen Narasaki. Becky Nagai. I'm sure that so many of you were able to fly in to be here today. On behalf of ALJ, welcome to the Bay Area, and thank you all for your hard work and dedication in the pursuit of justice. It is my hope that the future lawyers present here today can make you proud. And now I would like to thank our sponsors, without whom we would be starving. So thank you to our platinum sponsors, Mark Mao of Boy Schiller and Flexner, Minami Tamaki Yamaguchi Kwok and Lee Foundation, the Jones Day San Diego's office, and the Asian American Bar Association of the Greater Bay Area, the Berkeley Judicial Institute, Williams and Connolly DC office, and Lei-Ann Miyamoto and Hoitzia, who donated in honor of the memory of Robert Rusty, who served on the Korematsu legal team. And now I would like to introduce our keynote speaker, Lorraine Van Professor Emeritus of the Seattle University School of Law, and a key member of the Korematsu legal team. Lorraine has demonstrated an ongoing passion for upholding our civil rights and has written and spoken widely on the wartime Japanese-American incarceration and its present-day relevance. She has testified before the U.S. Senate Judiciary Committee, raising the warning of the incarceration and opposing provisions of the National Defense Authorization Act that permit the indefinite detention of individuals without due process. She has also co-authored amicus briefs on behalf of the children of Fred Korematsu, Gordon Hirabayashi, and Minoru Yasui in Hedges v. Obama, a case challenging those same NDAA provisions, and in Trump v. Hawaii, challenging the Muslim travel ban. Before retirement, Lorraine was the co-director of the Korematsu Center for Law and Equality, which seeks to carry on Fred Korematsu's legacy by engaging in research, education, and advocacy to advocate for the causes of equal treatment and fair process for all. So now, without further ado, let's get going. Please welcome our keynote, Lorraine Benai.
Thank you so much, AJ. Really appreciate it. People hear me okay? Yeah, okay, good. Thank you, members of the Asian American Law Journal, especially AJ and his crew, Dean Chemerinsky and Berkeley Law, of course, for sponsoring this program and for all of you for being here today. My goal here is to provide a backdrop and an introduction to help set the stage for the stellar panels that are going to follow after me. I'll provide some historical background behind the infamous Hirabayashi, Yasui, and Korematsu cases, a brief overview of the evidence that was used to reopen the cases 40 years later, and then just some of my own thoughts about the continuing relevance of the cases here. Any understanding of the wartime incarceration, of course, has to begin with an understanding of the history of animosity against Asian Americans in this country. And so any understanding of the orders that led to the wartime Japanese American incarceration, of course, has to begin with an understanding of the history of animosity against Asian Americans as foreigners, unassimilable, and threats since they first arrived in the US. A history sadly that Asian Americans share with other communities of color and immigrant communities in this country. To provide just a few examples, in 1889, in the case of Che Chang-ping, the Supreme Court upheld a law barring Chinese who had lived in this country from re-entering. The court explained that it was beyond question that Congress could act to prevent foreign encroachment by, quote, the vast hordes of Chinese crowding in upon us. In 1905, the Japanese and Korean Exclusion League argued that we cannot assimilate with them without injury to ourselves. We cannot compete with people who have such a low standard of civilization, living, and wages. Newspaper headlines read crime and poverty go hand in hand with Asiatic labor. Japanese a menace to American women. Asian immigrants could not become naturalized citizens. In the landmark case of Ozawa versus United States, the court held that the law provided citizenship for only white persons, and after 1870, Black persons, and Asians were neither white or Black. At various points, as many as 38 states have statutes prohibiting interracial marriage between a Black or Asian person and a white person. As one scholar noted, anti-miscegenation statutes were based on the view of Asian Americans as unclean and diseased. When Japan bombed Pearl Harbor in December 1942, it was in this context of this history that already treated Asian Americans as foreign and untrustworthy. Fear, of course, gripped the West Coast, and the country turned on the Japanese American community. In the days that followed, the bombing leaders within the Japanese American community were rounded up. In the months following, the public, the popular press, civic organizations, public officials on every level of government called for the mass roundup of Japanese Americans, arguing that the entire group posed a threat of espionage and sabotage. On February 19, 1942, in response to these calls, President Franklin Delano Roosevelt signed Executive Order 9066, granting sweeping power to military authorities. Lieutenant General John L. DeWitt, the commanding officer responsible for the Western states, was delegated authority to implement DL 9066 on the West Coast and proceeded to issue a series of orders. He first issued a curfew order requiring persons of Japanese ancestry and immigrants from Germany and Italy to comply with the curfew, followed by a freeze order prohibiting Japanese Americans from leaving the West Coast except pursuant to further military order. That was followed by a series of 108 civilian exclusion orders that were posted up and down the Western United States on telephone poles, ordering community after community to report for removal from the West Coast. They could take only what they could carry. 120,000 persons of Japanese ancestry were removed from their West Coast homes, from babies in arms to the elderly. 2/3 were American citizens, including my parents, grandparents, aunts, and uncles, and the families of so many Japanese Americans here in this room today. They were first removed to temporary confinement centers, and then to 10 more permanent camps in desolate regions in the United States, in the interior of the United States. There were no charges against him, there were no trials, and there was no proof that any had engaged in or threatened to engage in any acts of espionage or sabotage. 3 men, challenged DeWitt's military orders up to the US Supreme Court. Minoru Yasui was a 26-year-old attorney living in Portland, Oregon, who walked up and down the streets of Portland with a copy of the curfew order in his hand, seeking to be arrested to challenge its constitutionality. Gordon Hirabayashi was a 24-year-old college student when he defied the military orders as an act of civil disobedience. He was convicted of violating both the curfew and exclusion orders, an exclusion order being a euphemism for the orders forcibly removing Japanese Americans from the West Coast. Fred Korematsu was a 22-year-old welder living just down the road in Oakland, California. He chose instead to remain in Oakland with his Italian-American fiancée, to remain with the woman he loved in the place that had always been his home, a right that he felt he had like any other American. In each of these cases, the court upheld the constitutionality of the military orders, concluding that they were necessary to protect the country. Gordon Hirabayashi's case was decided first. Like I have this audience right here. His case was decided first in June 1943 with Yasui as a companion case. In Hirabayashi, the court addressed only the constitutionality of the curfew orders. Although the court expressed deference to military officials, it still addressed the government's claims that its actions were justified. In arguing that the orders were justified, however, the government could not point to any evidence that Japanese Americans had committed or threatened to commit any acts of espionage or sabotage because there was no such evidence. Instead, the government argued the military necessity existed for two main reasons. One, because Japanese Americans had certain racial characteristics that made them prone to ally with Japan. For example, the government argued that the community was unassimilated, giving no mind to the fact that they were pushed out of society by racially discriminatory laws. Further, the government also argued without proof, for example, that Japanese American children attended Japanese language schools, which were thought to be ready sources of Japanese nationalistic propaganda. Secondly, the government argued that its orders were necessary because there was insufficient time to separate the loyal from the disloyal. This bald assertion was made despite the fact that the first removal orders didn't take place for over 3 months after Pearl Harbor was bombed. It took the Supreme Court another year and a half to decide Fred Korematsu's case, in which it addressed the more egregious orders removing Japanese Americans from the West Coast. Although the removal order, the order taking Japanese Americans away from the West Coast, was so much more intrusive than the curfew orders upheld in Hirabayashi, the court said that the same reasoning supporting the curfew order in Hirabayashi supported the removal order in Korematsu. Further, despite the fact that the orders were issued only against Japanese Americans, the court in Fred's case went so far as to say that this case was not about racial hostility. Instead, the court said his removal was necessary to protect our country. The court said Korematsu was not excluded from the military area because of hostility to him or his race. He was excluded because the properly constituted military authorities decided that military urgency demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily. And of course, the removal was not at all temporary. By the time the Supreme Court decided Korematsu, Japanese Americans had been in camps for over 2.5 years. 3 justices wrote vigorous dissents. For example, Justice Robert Jackson warned about the lasting impact of the court's decision, saying that a judicial validation of this order lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of urgent need. In the decades that followed, Fred, Gordon, and Min wished for an opportunity to reopen their cases. The opportunity came about 4 years later. In 1982, Professor Peter Irons discovered shocking documents in the government's own records. Those documents, with others found by archival researcher Aiko Yoshinaga Herzog, established that the government had suppressed, altered, and destroyed material evidence while it was arguing these cases before the Supreme Court. For example, Professor Irons discovered, that the final report of General DeWitt, which explained the basis for his orders and which the government supported to the court in Fred Korematsu's case, had been altered to make it support the government's argument. Remember that in Fred's case, the government had consistently argued that mass removal was necessary because there was insufficient time to separate the loyal from the disloyal. However, DeWitt's report explained that lack of time was not the reason for his orders. Instead, he said the reality was that one could never determine the loyalty of a person of Japanese ancestry, no matter how much time you have. You simply can't separate the sheep from the goats, is the way he put it. In essence, it expressed the racist notion that no one could ever tell whether a Japanese American had foreign loyalties or not. When it was discovered that the report contradicted the government's argument, it was ordered revised to align with the government's argument that there was insufficient time to separate the loyal from the disloyal, and the original versions of the report were ordered destroyed. One copy of the original report survived, was not destroyed, and a soldier who destroyed the report did not destroy his memo, appear saying that he destroyed the report. The Supreme Court in Fred's case saw only the altered version of the report. Further, the government had within its possession intelligence reports from the FBI, the FCC, and the Office of Naval Intelligence that flatly refuted DeWitt's claims that Japanese Americans had engaged in espionage and sabotage, and the government failed to disclose these reports to the court. The FBI and FCC flatly refuted DeWitt's claims that Japanese Americans had engaged in illegal short-ship signaling and radio transmissions. And Kenneth Ringel of the Office of Naval Intelligence said that a thorough investigation had been conducted of the Japanese American community and that any issues should and could be handled on an individual basis as opposed to mass incarceration and removal. Justice Department Edward Ennis urged his superiors to tell the court of these reports, warning that any other course of action would approximate the suppression of evidence. Sorry about that. He was overruled. So this is just an image of his memo. Based on findings that the government had lied to the Supreme Court, legal teams were formed to reopen Fred, Gordon, and Min's cases. Among them are these really incredible people here. We filed petitions for writ of error or notice. We filed petitions for writ of error quorum nobis. Quorum nobis means before us, and a petition for writ of error quorum nobis asks the court to correct a fundamental error committed before the court that resulted in a manifest injustice. It's similar to a habeas corpus petition, but quorum nobis allowed the conviction to be vacated decades after the sentences had been served. 3 identical petitions were filed, one in San Francisco for Fred Korematsu, one in Portland, Oregon for Yasui, and another for Gordon Hirabayashi in Seattle, Washington. Panel 1 will address the 3 cases, how they proceeded, the decisions that had to be made, and the strategic choices made. At the same time, the quorum nobis cases were happening. Congress was addressing the issue of the incarceration, and the Commission on Wartime Relocation and Internment of Civilians was charged with investigating the causes of the wartime incarceration and recommending appropriate remedies. In addition to conducting extensive research, the commission went all over the country to receive testimony from individuals who had been incarcerated during World War II. That, I think, was tremendously impactful to allow those who had lived through the incarceration to finally speak up about their experience and to be heard. Members of the Quorum Novus teams also testified before the commission on the suppression of evidence and on the constitutional violations that occurred. Ultimately, the commission concluded that the incarceration was the result of race prejudice, war hysteria, and a failure of political leadership, and recommended a national apology, reparations of $20,000 each to persons who were incarcerated, and the establishment of an education fund to help ensure that the incarceration or things like it would never happen again. I know my friend Eric Yamamoto will be talking later on about reparations efforts. Let me close by just mentioning a couple of thoughts I have about the continuing relevance of the incarceration. First, as we find ourselves in the midst of a national conversation about race, the Japanese American incarceration teaches us much about the roots and cause of racism. How time and again, the rights and human dignity of vulnerable communities have been sacrificed when the majority feels or are led to feel that people who are different from them are a threat to their personal or economic well-being. We've seen this happen throughout history, and still today, as Muslims, people of Middle Eastern descent, and people believed to look like them are cast as terrorists and maligned based on their beliefs and dress. As persons of Mexican ancestry are branded as illegals and criminals, as Blacks continue to be subject to discrimination and violence. Viewed as lesser and dangerous, both as a result of overt, intentional discrimination, and also because of deep-rooted and unconscious, but just discrimination, just as pernicious. We simply need to look at the resurgence of anti-Asian violence to be reminded that the same stereotypes against Asian Americans that led to the wartime incarceration continue to exist, forever foreign, dangerous, diseased, lying about just under the surface, raising their ugly heads from time to time. Further, the wartime incarceration teaches as much about the role of courts and lawyers. In this regard, courts need to fulfill their constitutional duty to act as a check on their coordinate branches of government. You will hear on panel 2 a discussion of Trump versus Hawaii, where the court again deferred to a government decision based on national security and purported to overrule Korematsu, and the question is whether they really did. Also, with regard to the role of lawyers, the Quorum Novus cases raises issues about our lawyers hired guns who need to achieve justice, no matter what the cost, like the lawyers who were the agents, the engineers of the wartime incarceration, the lawyers who suppressed, altered, and destroyed evidence, or lawyers who seek to achieve justice, like the pro bono lawyers during World War II, who represented Frank Gordon and men, and my incredible colleagues on the Quorum Novus legal teams who volunteered their time to overturn the convictions. Finally, the incarceration tells us that we all have to speak out. During World War II, very few people stood up with the Japanese American community and opposed the incarceration when it occurred. My hope is that the panels that follow will be illuminating, and particularly to those of you studying to become lawyers. My colleagues on the Quorum Novus legal teams are my heroes. When given the opportunity to help address an egregious injustice, they said yes. Almost none were experienced federal court civil litigators. I was 2 years out of law school when we started the case, but I have to say that the people who made up this legal team, these legal teams, were some of the smartest, skilled, and committed people I've ever had the privilege of knowing. You'll still all be just like them, possessed of a bar card and unique access to knowledge and the support system sorely needed to aid people and communities to achieve justice. Thank you so much for having me here today, and it is my pleasure to hand the stage up here over to David Shin and our first panel of lawyers with the Quorum Novus legal team.
Good. All right. So first off, from the table, Dale Manami. Dale Manami was a lead counsel for Korematsu and has been involved in numerous other civil rights litigation. He's senior counsel at his firm, Manami Tamaki, and was a founding member of the Asian Law Caucus, the Asian American Bar Association of the Greater Bay Area. Welcome, Dan. Peggy Nagai was a lead counsel for Yasui and has served in a variety of academic and policy roles in her career, including an appointment from Bill Clinton to the Civil Liberties Public Education Fund Board. Peggy currently runs her own consulting firm as a principal consultant, and additionally is finalizing a book that she co-authored. Welcome to Peggy. Rodney Kawakami was a lead counsel for Gordon Hirabayashi and has participated in numerous civil rights cases throughout his career. Rod is a sole practitioner and enjoys volunteering at community legal clinics in his free time. Rod is also a founding board member of the Northwest Immigrant Rights Project. So welcome to Rod. And lastly, but certainly not least, the Honorable Judge Mary Schroeder authored the opinion in Gordon Hirayashi's Quorum Novus case. Prior to serving on the Ninth Circuit, of which she was the first female chief judge, she served on the Arizona Court of Appeals and was a trial lawyer with the U.S. Department of Justice. Please join together with me to give a warm round of applause to welcome Judge Schroeder and all of our distinguished guests on this panel. Then I think to get started off, it's Dale. Let's hear about the Korematsu case.
First, thanks to Lori Barnett for a wonderful summary. Guys, I just want to give a moment of respect. We lost two core members of our Quorum Novus team. One was Karen Korematsu's husband, Donald Hay, was totally supportive of us, and the other was Bob Rusky, who was a remarkable and incredible core member who did so much for our team. So just thinking of you. So let me go ahead and just talk about this chronologically. I think there's a bunch of questions here, so much hard for me to answer. So I'm just going to go and talk about how that didn't count. But I remember the spring day when Peter Irons called me up. I didn't know this man. He told me that he had discovered evidence, along with Aiko Yoshinaga, her researcher, that the United States Supreme Court was the victim of a massive fraud in the cases of Hirabayashi, Korematsu, and Yasui. We, of course, have read those cases in law school and despised them. We knew about the history of incarceration, although there was not a lot of literature about the time. Peter was a professor and a lawyer at Amherst in Massachusetts. And I said, how did you get my name? And he said that Min Yasui, a civil rights leader from the JCL, gave and for Colorado, gave Peggy's client and a petitioner had recommended some people. My name came up because Peter, who was Caucasian American, wanted a Japanese American to run these cases, and they had to find someone on the West Coast. Not a lot of Japanese Americans or Asian Americans at the time did much by way of civil rights work, although that's what I was doing primarily for years and years. So when Peter called me and told me that he had evidence of fraud and that there was a suppression, alteration, and destruction of evidence that was hidden from the United States Supreme Court in these three landmark cases, My first question was, are those guys still alive? Because this is 40 years later, you know, their names in a law book like Linda Brown or Neuer Neff, whoever. I don't even know if they're teach that anymore. But I was a bit skeptical. I was stunned because for years I had hoped to be part of some effort to impact these odious cases. So I asked Peter to send us the information. And he had also told me that he was still, you know, they were definitely alive and they wanted to revisit their cases again and challenge them again. And I was, first I said, well, how did you even find out where they were? And he said, well, the phone book. And of course, I have to explain that to this generation. Lawyers where a phone book was then. And he assured me that they were interested. So I said, send me the documents. And I then contacted, the first call was to Don Tamaki, who was the head of the Asian Law Caucus at the time. I recognized that this was going to be a massive undertaking. We were in a sense going to retry history. But we needed people in Portland and Seattle as well. So after I called Don, and I had asked for the documents, I contacted the only Japanese American attorney I knew in Oregon, and that would be Benny the guy. I think I met her at the bar. And Catherine Bonai in Seattle had already been involved with the Hirabayashi redress movement. And so she'd already had a relationship, and by coincidence, Catherine happened to be my law clerk in the summer law clerk, and the sister of Lori Bonai, who was a speaker here. So the other coincidence is that another attorney, Japanese American, that I worked with on an impact case, and Lori worked on it too, suing Spokane, Washington State University, was Rod Kawakami. And by coincidence, of course, he had experience, and we've done this case together. We just finished the case when we got this call. And so Rod was willing to work on it along with Catherine Bonai, who was first lead counsel. We met with Peter because once we got to review the evidence, it was stunning. It was in black and white. It was a smoking gun set of evidence where the lawyers for the United States government had admitted suppressing, altering, and destroying evidence. And the ethical ones told their bosses, the Solicitor General, this would be highly unethical. We didn't reveal this. This is contrary to the evidence we are presenting in the Supreme Court about Japanese American disloyalty, about Japanese American instances of espionage and sabotage. And what we have is contrary to everything we're arguing. Well, that evidence never found the light of day, nor the changes in the report that changed in 180 degrees from insufficient time, from sufficient time to insufficient time, or vice versa. So when we met with Peter, we didn't know what to expect. We knew that he seemed very credible. He was a professor. He was also a lawyer, trained at Harvard. Not as good as Berkeley, of course, but secondary school. And we met with Peggy and Catherine came down and Rodney too, along with other folks, and we sat around for several days discussing this evidence. What are we going to do with this? Peter had drafted a petition from Literary Corum Novus. We, of course, had to go to our Black's Law Dictionary to figure out what the hell that was. And when we learned like habeas corpus, well, you know, it became easier to wrap our arms around. We thought the evidence was compelling. And so when we moved to with these different groups of people, we first initially had to decide where are we going to file. Some folks thought the Supreme Court, some people thought the Ninth Circuit, but we eventually hit on a strategy to file in 3 separate courts, which is actually legally the right way to do it. If we filed with the Supreme Court, for example, one, if we got kicked out early, it was a conservative court, would make a big splash, but wouldn't have a big loss right there staring us in the face. So we thought, well, the idea would be to file in 3 separate courts, and in this way, we would have 3 chances, 3 bites of the apple, as we would call it, to get a favorable ruling or even unfavorable, if we got some combination, we could then appeal. Because ideally, we wanted to get to the Supreme Court. Quorum nobis doesn't allow you to challenge the constitutionality of the law. You can only work with facts. Nevertheless, we inserted count to overturn Korematsu and Hirabayashi, Yasui, which was not accepted later on. We did these cases in the context of the redress movement. We understood why we had to do this, not just for a narrow, even though it was landmark cases earlier, legal reason, but to be able to educate this public about the truth of the allegations made against Japanese Americans. We want to educate this country. Legally, we had a chance to impact or impair these terrible, awful, heinous decisions that we all read and despised. And then personally, our parents, for many of us, were incarcerated. And to vindicate them, I think was one of the strongest motives for us to continue to take this case. Finally, we wanted to make sure that the petitioners, who were courageous men who stood up, later on, Mitsugi stood up, but that was in a different context. But these men were able to withstand essential ostracism by their own community, and were impacted by the decision that put their own people and validated their imprisonment in camps, in prison, we should call them, for years and years and years. What was critical too is that we needed a judgment. We needed a written decision because the opponents of redress were requesting $20,000 in apology in front of Congress. The opponents were arguing that, well, wait a minute, this has been resolved already. In 1943, 1944, the Supreme Court upheld essentially incarceration, not so much incarceration, but close to that exclusion and curfew was legal. So we needed a counterweight for our proponents to argue that those were imperfect decisions. They were impaired, but not only they were impaired, they were wrong. So we had this group. Strategically, we were going to file in San Francisco first because it was the most receptive panel that we could get. And as a lot of you all know, that the panel you get is already cheap. The judge that you get may determine the outcome in terms of the case, the civil rights case. And our first choice was Marilyn Hall Patel, who was a judge in Oakland Piedmont Municipal Court. We knew her, and she was appointed by Jimmy Carter. Elton Henderson, African-American judge, who was appointed at the same time, was our second choice. So we had a good sense that we might get somebody good in San Francisco. The second choice was Seattle. There was one judge there named Donald Voorhees, more amenable to the ideas of civil rights, and with courage, he was very intelligent. In Portland, what can I say? Peggy will talk about that. We throw our hands up and hopefully you would get somebody. So we're going to do this in sequence based on who got the best judge. If we got a good judge in San Francisco, our first choice, we'd stay there, try to begin with proceedings. And then if that bad judge or didn't like as much, then we filed the next day in Seattle. And then finally our default was Portland, Oregon. We got into the clerk's office. We had a pile, this high of petitions and appendices, and we realized that the choice of who you get as a judge is always random. Peter and I are on the Bridge of Glory, where we have these petitions, and we're going to the toll plaza, and it takes forever because the shortest line yielded the longest wait. And I thought, I'm lucky, never want a raffle. Peter goes, "Did you need to? I am so lucky." And we looked at each other. We thought, huh? So we looked back and we thought, Lori Bonai. We thought, no, this is somebody who's got good karma. We gave all the petitions to Lori, told her to file it. Lori eyes got like a table. And she knew what was at stake. We filed the petitions, the clerks knew what was happening, so they turned around and told us, smiling, "You got Marilyn Hall Patel." And we were slapping high fives, we were totally undignified. But the clerk the clerk of the court had to come out, the clerk, and say, what kind of petition is this? I haven't seen this in 30 years. Do I file it as civil or criminal? And I immediately said civil. We wanted this file as a civil matter because then we got discovery. Not like the criminal cases where you couldn't get discovery. We got discovery. We were then able to do depositions and interrogatories, requests for admissions. Anyways, so we formed our teams, we filed the cases, we got Northern Hospital, we proceeded to litigation. And I almost got time, in fact, I will. So the last part I would say is that in talking about, as we went forward, there are many other examples based on this. But as we passed the courtroom with a lot of East Japanese Americans who never had a day in court, they got to have the trial they never had. And while we didn't expect a ruling that day from the bench, which is rare, Judge Patel offered that ruling to the entire courtroom. It was a dynamic ruling which upheld our petition, overturned the conviction. And in the words in the transcript of the decision, she talks about the misconduct, the misrepresentations by a military officer who was seriously affected by racism, that there was alteration, suppression, and destruction of evidence to the degree that maybe the courts would have changed their mind, but it was enough that the misconduct allowed her to make the decision to overturn the case. Now, if you read the case, I had done this about 10 times, and I keep getting it. If you read the written opinion, a lot of that is not in there. Racism part, it wasn't as strongly worded, and I think it was intentional, and it was brilliantly intentional. Because she gave us a political victory. She gave us a chance to argue into Congress and opponents why these cases were so important, why they were so terribly, the rulings were so terrible. And yet, when she did a written decision many months ago, in March, I think it was, after the November hearing, she made it really tight and bulletproof. And to that extent, the government appealed and they dropped the appeal. The other petitioners had a very, very different experience, and they're going to tell you about their experience. But of course, we can take questions if you have any. But thank you very much.
Thanks, Dale. First of all, thank you to the Asian American Law Journal for putting together this symposium. And I didn't realize it was based on a memo from Dale called "Let's Get It." Also, thanks to Aika Yoshinaga, who's no longer with us, but who found one of the smoking guns. It worked for you.
Roll the bike, I'm sorry. Close.
Who also, I don't know, what the other smoking guns. I want to talk a little bit about, and then I want to thank the audience here. Because this audience is like, raise your hand if you're a law student. Look at all those law students. This was not, I'm going to start my time now. This was not like the law school I went to. So thank you for being here. Thank you for your work, your activism, and we are counting on you because we really need you. I want to talk a little bit about Yasui himself, and then the legal team, and then the court decision, the prosecutor, Judge Maloney. Yes, that was the name of the judge. And what this meant to me. So Yasui was the third son of Japanese immigrants, Isao and Shinosu Yasui. He was born in Hood River, Oregon, and lived on a farm. And from an early age, he was really an activist. He started a chapter of the Japanese American Citizens League when he was 15, and presided as president of that. He graduated from Hood River High School as valedictorian. He's a double duck, which means something these days, but he went to the University of Oregon, undergrad, Phi Beta Kappa, ROTC, and then he went to the law school, graduated in, I think, 2 years from law school, or maybe 3 years for undergraduate. He was the first Japanese American member of he was the first Japanese American graduate of the University of Oregon Law School. He's the first Japanese American member of the Oregon State Bar. So can you imagine yourself? Put yourself back there, and then say, okay, this curfew is coming down. And I know enough about the law to believe that this is unconstitutional based on US citizenship. And what am I going to do about it? What would you do about it? 25. Tried to find a test case, he couldn't find a test case, he became his own test case. And what he said later on about why he undertook this is the United States of America, founded in liberty, dedicated to the proposition that all men and women are created equal. As an American citizen, as a lawyer, I felt that we owed at least the obligation as a citizen to tell our government they are wrong. That is the sacred duty of every citizen, because what is done to the least of us can be done to all of us. I knew we had to protest. The Yasui legal team I started the case when I was practicing in Portland. I got a job at the University of Oregon Law School as an assistant dean. The dean was Derek Bell, who many of you may know. Derek worked with Thurgood Marshall doing desegregation cases. He's considered the godfather of critical race theory. Can you imagine me in Portland going to Eugene to have him as the dean? So I said, I would be honored to work with you, but I have this case, and if I can't bring the case with me, I can't accept the position. Derek understood. He said, bring the case, bring yourself, come to Eugene. If my community asked me to do a case like this, I would take it in a heartbeat. So what better to have Derek Bell as your boss and Min Yasui as your client? Life doesn't get much better than that. The other people on the legal team, Mary Mori, Fern Ng, and Bert Fukumoto, and myself, the 4 Asian lawyers in all of Eugene. That was it. Don't laugh. So we had law students. Jeffrey Beaver, who was a law student at the U of O, worked on the Yasui case, became a lawyer, went to Seattle, worked on the Hirabayashi case. Wes Kadahira, James Egan, other law students. And then I recruited Don Wilner, who was a civil rights lawyer in Portland, who started practicing law the year I was born. Went to Harvard Law School, so really well, very intelligent civil rights lawyer. Frank Schumann, who many of you may know, who wrote Bamboo People, who was a friend of Min's for many, many years, practiced in Los Angeles. Frank, I think, lives in Thailand, and he's 104 years old. And I sent an email to him, but he couldn't make it today. And then there were others, Steve Griffith, Scott Meisner, Clayton Patrick. We had a legal team all up and down I-5 from Portland to Eugene, multi-generational, multicultural, diverse legal team, which was something in and of itself. We also had Karen Kai and Bob Rusty as our members of the team. And as we said, I can't remember if we had faxes back then, but we certainly didn't have cell phones. No. So we edited things with Bob and Karen by telephone. Remember those things? You know, and other members of both legal teams were part of our team. It was pretty amazing to do this case from Oregon, which is, you know, Oregon, Portland is the whitest city in the whole country. Oregon became a state as a white-only state. So it has an anti-democratic justice background. So the issues in the case, we filed on February 1, 1983, a petition identical to Korematsu and to Hirabayashi in the District Court of Oregon. Victor Stone took 7.5 months to reply to our petition, similar to what he did in Korematsu. He said that it was inappropriate to defend a 40-year-old misdemeanor conviction. He agreed that the conviction should be vacated, and the petition for quorum nobis relief, however, was unnecessary and should be dismissed. He said we should put this behind us, that it's not relevant, that there's no controversy, that there's no continuing reason in this setting for the court to convene hearings or make findings about the petitioner's allegations of governmental wrongdoing in 1942. And he further argued, while he agreed that Yasui's conviction should be vacated, there's no need for legal and factual findings. He moved to dismiss the original indictment, hoping to render the petition moot and avoid any inquiry into governmental wrongdoing. Our response, we argued that the conviction ought to be vacated, but we argued for findings of fact and conclusions based upon the government's failure to respond either to the allegations of the evidence set forth in the petition and in Korematsu, but we also argued that there were fundamental issues in the original case that of undisclosed evidence of governmental misconduct and lack of military necessity to justify the curfew, exclusion, and incarceration. These stated errors were of such a fundamental character that they denied Yasui his Fifth Amendment right to a fair trial. However, unfortunately, we did get Judge Maloney, who disagreed with us and agreed with the government. So this is why the cases went off on 3 different ways. He disagreed and treated the charges of governmental misconduct and the denial of due process as dead issues, insignificant issues. And while he vacated the conviction, he did so by granting the government's motion and dismissing our petition. We didn't get the evidentiary hearing, which Yasui desired, on the claims of governmental misconduct. Here's what Bologna held. The 2 responses from the government and from Yasui reached the same result. The only difference is the petitioner asked me to make findings of governmental acts of misconduct that deprived, my time's up, that deprived him of his Fifth Amendment rights. That's like saying these 2 things are the same, only there's like an ocean of difference about why we want the ruling. That there's a difference in finding evidence and finding governmental misconduct. But he basically said, this is not a case of controversy. since both sides are asking for the same relief, only for different reasons. That's like saying that the Democrats and the Republicans really want the same thing, only for different reasons. How many of you would believe that? Sorry, it's getting political, but I am political. So the petitioner would have the case engaged in fact finding, which would have no legal consequences. The court should not engage in that kind of activity. It was bittersweet. Okay, we got the conviction vacated, but we didn't get the hearing on the documents. So no education for the public, no realization about what happened, and in essence, really no healing for our community. So as Dale said, they wanted to file as a civil case. I filed an appeal, but I filed it in the civil time frame instead of the criminal time frame. The government moved to dismiss that based on that, and we had to take that issue up to the Ninth Circuit, which we ultimately won, but we lost some precious time. Precious time that I didn't realize we didn't have. Because Yasui passed away on November 12th of 1986 while we were still appealing his case. And it still is horrible to think about today. Did not get the day in court that he so wanted. So the Ninth Circuit agreed with the government, dismissed the case as moot. We filed a writ of certiorari to the U.S. Supreme Court. They denied the writ. We filed another motion requesting a rehearing of the original writ based on newly discovered evidence, which I'm not quite sure what the newly discovered evidence was, but they also denied that. And so the case was done, unfinished, dissatisfied, really sad. And the one last thing I would say is that there's many things that I regret, and that's one of them. So I was really happy and proud to work with Holly Yasui, Min's daughter, to form the Min Yasui Legacy Project, and to have a successful nomination for Min for a Presidential Medal of Freedom. And we did that. We knew that if we didn't get it while Barack Obama was president, we might never get it. So we had a successful nomination, and Barack Obama awarded him posthumously a Presidential Medal of Freedom. And Holly and I were there at the White House to see that happen. Later did I realize he's the only warrior that's received the Presidential Medal of Freedom. So more to tell, but I'm way over time. Thank you.
Okay. I want to say thank you to AJ for inviting me to participate in your symposium today. And I want to tell the students back there that I was also always in the back of the class. And I want to start with a little story about how I felt about being a young attorney joining the Quorum Novus team. So I was on the airplane coming to San Francisco to join the two other teams. And I'm thinking to myself, there's going to be 20, 25 attorneys in the room. And I'm saying, with attorney egos, how is that going to work? So I get to the office, Dale's office, at the time he's moved, and I understand. But I get to the office and I sit down and there are 25 attorneys sitting around the table. And I feel, boy, all these egos are filling up the room already. And I said, this isn't gonna work. And it was Don who started the meeting and he said, this case is too important. Everybody park your egos outside and let's get to work. And with that, the room kind of shrank down to normal and we all started working together. We've been working, I think, pretty well ever since. So one of the things the three legal teams decided was that we made a promise to each other that we would have a commitment to use this case as a tool in an educational campaign to champion the need to protect constitutional rights, especially in times of crisis. And so true to our commitment over the last 40 years, I've been on panels before with Peggy and Dale and with Lori. And we've, I think, fulfilled our commitment that even 40 years later, we're here today, still preaching. In our case, procedurally, Plan A actually was for the three cases all to consolidate into one case, and then Dale in San Francisco was going to be the lead attorney and take over everything. But when the government objected and the courts refused to consolidate the cases, each of us then had to devise our own Plan B. And for our case, we were assigned, as Dale said, to Judge Donald Voorhees, who was rated by the trial attorneys at that time as the best judge on the West Coast. And the strategy was, for our Plan B, was to bring a motion for an evidentiary hearing to fully lay out all of the evidence in open court and hope that we can get a judicial ruling on the merits of our petition. So at the time, Catherine Bonai, Lori's sister, was our first fearless leader, and she was responsible for organizing the Seattle legal team. And she also argued the motion successfully. But after we won the motion, I guess it fell into the category of be careful what you wish for. Because after celebrating and pitching ourselves, we were hit with the realization that we need to prepare for what one of our attorney members, Arthur Barnett, would often say is the trial of the century. Now, Arthur was one of Gordon's attorneys, his original attorneys back in World War II, and he also was still alive at that time. And he became the conscience of our group, even in his retirement. And Arthur attended all of our strategy meetings, and actually, as a sign of respect, Judge Voorhees allowed him to sit with us at council table throughout the whole trial. But sometime shortly after Catherine successfully argued the motion, her husband, Robert Miura, who was a mathematics professor, accepted a teaching position up in Canada. So when she moved her family up to Canada and handed the torch off to me, and I became the lead attorney. Another member, Camden Hall, was one of Seattle's top litigators at the time. And he not only had extensive federal trial experience, but he also had recently just tried a case before Judge Voorhees. So I asked him to be co-lead attorney along with me. Beyond the legal preparation that we had to do, the costs of litigation would be significant since our case took us from Seattle to New York to Hawaii and of course traveling down to California. So we had to do some fundraising to keep the case afloat. And back in the day, we didn't have things like GoFundMe, so we had to have a public education campaign and added a media component and in a public education part of our legal team. This meant that me or one of the other attorneys had to go basically door to door speaking at churches or community organizations or whoever would invite us to explain the case and its legal importance. Because all of the attorneys were working on this basically pro bono, and since I was a solo practitioner without the advantages and resources of a large firm, we divided the workload and had Roger Shimizu and Diane Narasaki as our community liaison persons. Gary Iwamoto handled much of the media relationships, and Mike Leon was our overall coordinator and contact person with the two other legal teams. And it was really important to us that a Japanese American attorney, particularly a Japanese American woman, be the public face of our team. And maybe different today, but at that time, there were very few Japanese American attorneys, in effect, very few minority attorneys. And we were very fortunate to have Peggy and Catherine as our leaders. And our core Seattle team consisted of about 13 or 14 attorneys, including a Latina. We had an African American attorney, Chinese and Japanese Americans. We had several Caucasians. And one of Gordon's favorite sayings was that this is not just my case, and it's not a Japanese American case. This is an American case. And so we intentionally wanted to have our legal team diverse as possible to reflect this principle. As to the trial itself, between the 3 bites of the apple that we got, the government also had 3 chances to come up with a defensive strategy. And since ours was the last case, and because our case was being tried on the merits of the case, the government strategy, oddly and to me very disappointingly, their strategy was to repeat its old debunked World War II arguments. But in addition to being our legal team coordinator, Mike Leon was also what I called my government whisperer. Victor Stone was a government attorney, and Mike seemed to understand Victor Stonese a little better than I did. So I would have to ask Mike, is he really arguing that the government believes its actions is justified on military necessity? He would tell me, yes, Rob, that's what they argued. And I would ask him, is he saying that Magic Cable supports the government's actions? And again, he would say, yes, that's what they're saying. I didn't always understand the government's tactics or what Victor Stone was saying, but I'm happy to have Mike as my interpreter. So in our case, we had a week-long trial, and the witnesses included Edward Ennis, who was part of the government's legal team at the time, and he was one of the attorneys that helped prepare the government's brief to the Supreme Court during the World War II cases. But he came to testify on our behalf and was one of our most powerful witnesses. We also had as a witness Aiko Hertzog Yoshinaga, who, as mentioned before, found in the archives the crucial smoking gun document. And Peter Irons, who had the experience with quorum nobis, so we know how we could use quorum nobis, which is probably a very little-known remedy that most people don't know about. So we were lucky that he had the knowledge and the ability to be able to help us out. Now, during the trial and actually before the trial, I don't remember whether you guys experienced this, but the government would, in desperation, try to offer Gordon a pardon. And I can remember when it first came up, Arthur Burnett turned to Gordon and said, Gordon, the government should be asking you for a pardon. So with the pardon issues, we gave it all due respect that it earned, and we went on without accepting it. So let me finish by just saying that one of the government's arguments that we thought maybe would be problematic for us is the issue of blackness or a mootness argument, which was that in order for the government to prevail, Gordon would have to show that he suffered some adverse consequences as a result of the wrongful conviction. And since he was a well-respected sociology professor, the government submitted that he could not show any adverse consequences. So in addressing that argument, and one of the biggest takeaways I got from the judge's decision, and two words that always stuck with me, was lastingly aggrieved. And with that, I'll turn it over.
Thank you. I want to thank everybody for putting on this symposium. It's been an experience to be back with these wonderful people. I also wanted to say that these cases were all superbly presented as lawyers, and I'm glad that we've all survived the last 40 years so that we can be here with you. I think that what you have in these cases, these three cases, they all came, of course, from the Ninth Circuit to the Ninth Circuit, and they represent three very different records that I think is worth noting. The Yasui case, we'll start with the Korematsu. Korematsu case came up to Judge Patel, as I understand it, on motions. And the government wanted to nolly-cross the whole case and say that we just wanted to go away. We were going to say we never prosecuted. And Marilyn Patel said, no, you're not going to get away with that. And she granted Korematsu's petition on the motion. The Yasui case came out sort of the opposite. And Judge Bologna, who was a very well-respected judge in Oregon, Judge Bologna believed that, and it's B-E-L-L, he believed that that the case was not really worth granting of risk, and he just dismissed the whole thing. So when we get to Hirabayashi, Judge Voorhees, who was a very shrewd fellow, Judge Voorhees actually held a full trial, and he held a trial on the merits. And I think if there's a government hero in this case, it's Edward Ennis, who was the lawyer in the Justice Department, who tried to insist that they tell the truth to the Supreme Court, and the Solicitor General refused to do that. And then all the truth came out in the 80s. And I think historically it's interesting to note that these cases came to the courts, back to the courts, in the 80s at a very fortuitous time, because in the 80s, the people who had been incarcerated during the internment, many of them were still alive, were still well, were still feeling very much victims of an injustice. And at the same time, you had a younger generation of judges coming up who represented the great diversity in this wonderful country, and who had not experienced World War II, but had experienced discrimination. And so I think it's interesting if you look at the judges, and the panelists talked about them. Judge Patel, who was a dear friend of mine, actually worked for the National Association for the, now, the National Organization for Women. She was an attorney for them before she was appointed to the bench by Jimmy Carter. Judge Maloney, was an old school. He was born in 1919. He lived through World War II. And he had a different historical perspective. And our panel on the Ninth Circuit was very interesting. We don't get to choose our cases. We don't get to choose who we sit with. But we were there in Seattle, and it was an interesting panel because the senior judge on the panel was Judge Ted Goodwin of Oregon, a legend in Oregon, a wonderful judge. He had fought in World War II, both in Europe and in the Pacific. And he, I don't think, was favorably disposed toward the petitioners in this case. But then you had Jerome Ferris, who went to Morehouse College, was raised in the South of African American. And during the oral argument, the one thing that he wanted to make clear in the record was that these people who had been incarcerated in turn were American citizens. Once he put that on the record, he was done. You know, the case for him, he understood it was over. And of course, I was a young judge at the time, having been appointed by Jimmy Carter, and I had come up at a time when women were not wanted in the legal profession. And I really think that if these cases had come up 10 years earlier, they would have come out in a different way, because you would not have had the judges who had actually experienced been victims of discrimination, and you would have had a generation that had fought World War II. And so I think history is really important here, and judges' backgrounds are very important, and diversity is very important. And I think that is a lesson for all of us. I do want to say just a word, I don't know how much time we have, but I do want to say a word about Gordon Hirabayashi, because he is my personal hero. I regard the courage that he showed in standing up to the United States government as absolutely phenomenal. I got to know Gordon after the case had been decided, because some people were giving a party for me, and they decided to do something really extraordinary, and so they found Gordon Hirabayashi up in Canada and brought him down to the States for the party. And he stayed up all night telling us about his experiences. And Gordon Hirabayashi was a man of great conscience. And when his case was decided by the Supreme Court and he lost, he wanted to serve his sentence. And so he was up in Washington, and the government was in the middle of the war, didn't have any way to get him to prison. And so he hitchhiked from Washington all the way down to the prison camp, which was in Arizona, in order to turn himself in. They didn't know who he was. He told him to go to the movies, and they tried to find some papers on him. And he came back and he served a sentence. And the place where he served that sentence, the camp, is now a rest area in the Catalina Mountains that's named for Gordon Hirabayashi. And I was there with him the day that was dedicated. And it was quite a moment. If you can imagine being in a place where you would have been in prison and had named after you, which I think is kind of the ultimate vindication of these three men who stood up to return them. And I think that we should just think back on the history of this and be very, very grateful that it turned out the way that it did, that the lawyers who did so much on this stuck with it, and for the historians who worked on this and found the evidence in order to make this great injustice reach some measure of vindication, even though it was too late. And I think the epigram for some of this is that the title of the book that Peter Irons put together all of the documents relating to the internment, and it's called Justice Delayed. And I am very proud that in that document, which starts out with the beginnings of all of the cases, including the original Supreme Court case and the cases in Korematsu, Yasui, and Hirabayashi, that as you go through the whole book, I get the last word. And that's because the government did not appeal the Hirabayashi case to the Supreme Court. Hirabayashi himself was furious at this because he thought that the Supreme Court ought to have the last word and vacate his conviction. I'm not at all sure that that would have happened. So I'm very, very proud to say that I was able to decide this case that was so superbly presented with such a superb protagonist and to have the last word. And thank you for having this program.
So if I could just add one more thing. In addition to that, Gordon also had the jail, he was in King County named after him. So he also had, after the trial, he also, in addition to his appeal judge, he also had a kind of a social relationship with Judge Voorhees after a while. So he got to know both judges personally after the case. That's the kind of person he was.
And if you want to see the cell that Min Yasui spent 9 months in solitary confinement in the Multnomah County Jail, it's now at the Japanese American Museum of Oregon. So they got the cell from the jail and they installed it in the museum. So come up to Portland.
Awesome, well, thank you again. Back. We'd like to open up for a short audience Q&A. If anybody has any questions, I can give you the microphone. Don't be scared. For me personally, what were you thinking the morning of the decision? You know, was there any kind of, obviously as a judge, you sort of be what's going on, but you know, when you were litigating these cases, did you understand the day of, you know, where it was probably going to be headed? Sorry, all three form notice cases.
Yeah, good. For years. No, so the day we had met the night before, Judge Patel called counsel into chambers, the counsel. So I was there with Victor Stone, and she told him that you have not responded to the petition. So I'm thinking this is a confession of error by your failure to respond. He said, well, I can't get a hold of my superiors. And she said, well, you go try it right now, okay? So, you know, tomorrow we're in court. I'm going to rule that you, the government is not made a non-response, which is tantamount to a confession of error. So I saw Victor Stone. I felt sorry. The first time the only time I actually felt sorry for him. He's putting quarters in the phone, you know, phone machine. I forgot what they call it. And because he couldn't get a hold of him there at a conference, so he had no authority to make the decision. So Judge Patel said the next morning she called us both in and said, "Did you reach your superiors?" He said, "No." Well, the night before, I should say this, that we assumed that we were going to win, and that was the chapter of Peter's books. I think it's Justice Delayed, where I was crafting a closing argument with the help of our team. And by the way, I want to recognize them: Leanne Yasada from Hawaii, Eric Yamamoto from Hawaii, Lori Banai, and Karen Kai is here. Hoyt too. Hoyt helped at the start. He helped us eat all the leftovers. It's really good. And so we assumed we were going to win or drive. And so the night before, we kind of celebrated. We were drinking, and well, I wasn't so much because I was doing the argument for the next day. And so the next day we went in and went in chambers. Judge Patel said, Mr. Stone, have you received a response? He said, no. He said, well, I'm gonna rule against the government and let's do it. Let's go out there. And so by then we knew we were gonna have a decision in our favor. We didn't know what it was going to be exactly, because whether it was gonna be a written decision, have the findings of facts, that which we wanted, and conclusions of law. We had hoped that would happen, because we needed that judicial declaration first time in this whole episode of the redress movement. And so that's exactly what the judge did. It was very surprising. And when she ruled in our favor, we were standing up there, like many of the council, we all were there. And I looked at Fred and I said, Fred, this is great. And he looked about 2 feet over my head and staring at me, and he said, what happened? I said, Fred, you won. And he didn't avert his eyes, he kept looking 2 feet over my head, and he said, that's great. And I could tell, I knew immediately all these years of having to bear the burden of losing the case that validated the written imprisonment of his own people, that this was something that was too hard immediately to grasp. And so later on, as we sank in, Fred became very, very happy.
Richard Wilson had a question. So should we go to him? Richard, stand up.
I wondered if any of you experienced the 442nd Regiment Japanese soldiers fought in World War II. I was aware of a lot of it because I knew the spouse of one of them. And I wondered if you also had experienced it. Everything on one side is not always everybody's happy. But they were not happy in my understanding. I wonder if any of you experienced that.
They were not happy about what?
For nobody at all. They felt they had said everything that needed to be said and done about Japanese American loyalty, and did not like these things.
From my experience, I think it was way more complicated than that.
All probably.
There were a lot of people, 442 vets who really supported us and liked what we were doing. But right after, during the war, World War II, there were a lot of opposition to Fred and Gordon and Lynn, even bringing this report. And a lot of 442 vets felt that this was kind of this chicken way out, and it's just spend time in jail, which was not something that was actually very courageous. So I think it was more split.
It probably was. Undoubtedly, because I was only hearing about the one side, the husband of the one that offer. But of course, the only thing worse would be a no.
Well, even at that time, the redress movement was just starting.
Right.
And there was an educational campaign even within the Japanese American community who also felt that this was an issue that's over and done with and we should let it go. And part of the redress movement that we're actually fighting for redress, I don't know, didn't appreciate, but thought that if we lost the case, that it would damage redress. So we had a little bit of blowback there too. But ultimately, we all got on the same page and we supported each other and got redress through. But as Dale said, there's different elements of the community with different perspectives. So we weren't all always on the same page.
Lori.
Yeah. So, our second panel is going to be talking some about high-profile cases and political cases and political lawyering. Judge Schroeder, I wonder what it's like from your side of the bench when you know you're going to be handling a case that has great public impact. How did you feel when you saw that you'd be deciding Gordon Hirabayashi's case?
Well, the question is how, because that's not working. The question was, how did I feel when I saw that I was getting this case? Because there are what I call face card cases that come along, or cases that have a great deal of public attention or have a political. And I guess I try to remain a little bit objective and detached. But my law clerk nearly went crazy when this case came into my office, because he came running in to my chambers and said, "This is the Hirabayashi case. This is the Hirabayashi case." And I said, and then I realized what it was. But of course, I had two colleagues, and the question was, how can we reach a decision in this case with an appellate that is going to be, if possible, unified and persuasive, and not go to the Supreme Court? And I think we were able to do that.
Judge Schroeder, how was it determined that you were going to write the opinion?
I don't really remember very well, except that it should have been Judge Goodwin as the chief judge on the panel. I think we all thought that he would want to write the opinion, but he didn't. And he deferred.
This Cameron, a hate crime that happened in 2019 when an elderly Vietnamese man was physically attacked. We are very proud to call Quinn as a member of the Berkeley Law alumni community. While as a student here, she co-founded the Berkeley Law First Generation Professional Institute, and in 2018, she was awarded the Young Alumna Award from our schools. Please join me in thanking her for being here. We also have Professor Eri Yamamoto with us from the University of Hawaii, where he is the Fred T. Korematsu Professor of Law and Social Justice. He is nationally and internationally recognized for his legal work and scholarship on civil procedure, national security, human rights, civil liberties, and social justice. Much of his work focuses on reconciliation and reparations for injustice. In 2020, Professor Yamamoto received the Daniel K. Inouye Trailblazer Award, the highest honor of the National Asian Pacific American Bar Association. Professor Yamamoto is also a proud alumnus of Berkeley Law and served on the Korematsu Quorum Notice team. As a litigator, he served on the legal teams in the Markup Supreme class action challenging political torture in the Philippines, the Tulsa Rape Massacre Black Reparations lawsuit, and the Native Hawaiian Homelands class action. Ever the prolific scholar, Professor Yamamoto published 3 books in recent years. Please welcome me in joining Professor Yamamoto. Our third panelist almost needs no introduction. Joining us is Dean Erwin Chemerinsky of Berkeley Law. He is one of our country's preeminent legal scholars and author of many books, including casebooks and treatises in constitutional law, criminal procedure, and federal jurisdiction. Dean Chemerinsky is also a public scholar, often contributing to op-eds in major newspapers across the country. Additionally, he frequently argues appellate cases, including in the United States Supreme Court. Often referred to as the most influential person in legal education in the United States, in addition to serving as Dean of Berkeley Law, he serves as president of the Association of American Law Schools. Please join me in welcoming Dean Chemerinsky and all of our panelists. All right, let's get going. So Dean Chemerinsky, if you would please start us off by talking about the relevance of Korematsu and the dangers of perceived national security.
Thank you so much for the kind introduction, and thank you for having me today. It's wonderful that so many people have come. Most of all, I want to thank all the students who worked so hard to put this together. So in my role as dean, can I ask for a round of applause for the students who brought it together? In answer to your question, Korematsu was a tragically flawed decision. Unfortunately, it continues to influence with regards to the courts, with the executive branch. Our country seems to be making the same mistake time and again. Think, for example, of Trump versus Hawaii, a Supreme Court decision just 5 years ago that upheld President Trump's travel ban. And I think of Korematsu, Hirabayashi, or recently Trump versus Hawaii, I see several mistakes being made. One is allowing dangers to be determined by the government based on group characteristics, such as race, ethnicity, national origin, rather than an individual assessment of dangerousness. That's what went on in World War II, when the federal government evacuated and turned 120,000 Japanese Americans from their lifelong homes. The government was making a judgment of dangerousness solely on the basis of race, ethnicity. Well, the government did the same thing with regard to the Muslim travel ban. President Trump initially banned those from 5 countries, then it was 6, then it was 8 countries from coming to the United States. Those 3 countries shared 3 characteristics. One is they were all more than 90% Muslim in population. Second, no one from any of those countries had ever been linked to a terrorist act in the United States. Third, Donald Trump owned no investments in any of those countries. But once more, it was about making assessments of dangerousness based on group characteristics, not individual assessments. And under our Constitution, no one should ever be able to presume dangerous on account of race or ethnicity or national origin. Second, the Supreme Court accepts uncritically government justifications of national security without evidence. I will more compare Korematsu and Trump, though I'd give other examples. With regard to Korematsu, not one Japanese American was ever indicted, let alone convicted, for espionage or any crime against national security. The research, Peter Irons and others showed that the government fabricated evidence, lied to the courts about the dangers of national security. And yet the Supreme Court was willing to allow the national security justification to permit President Roosevelt's executive orders. Same thing with regard to President Trump's travel ban. There was no evidence whatsoever that anyone from these countries posed the slightest threat to national security, and yet the Supreme Court upheld it. And closely related is third, is the Supreme Court abdicating its role of enforcing the Constitution. You have to ask, why do we have a Constitution? And why do we have a Supreme Court to enforce it? And I believe that above all, the Constitution exists to check the majority, particularly in times of crisis. Those who drafted the Constitution knew that especially in crisis, there'd be a temptation to centralize power and take away rights. And we most need the Constitution and the court to be there in these times of crisis. What Korematsu was, what Trump versus Hawaii was a terrible abdication of the Supreme Court of its preeminent role.
Thank you.
Thank you, Dean Chemerinsky. So maybe we can shift focus just a little bit, because while there is no doubt some aspects of economic threat implicated in Trump v. Hawaii, it was much more so in Korematsu. So Quinn, if I could hand it over to you to speak about the history of civil rights litigation in the US, especially as it relates to the HI community.
First, thank you everyone. Hello? Thanks everyone for inviting me. It's a great pleasure to be here. I want to thank the AELJ students, as well as Mark now who invited me, and it's such an honor to come after the panel that we just had. These folks are my heroes, and I'm hoping to be able to weave some of the themes from the last panel with ours to speak about some of the issues that Dean Chirinsky as well as Yamamoto spoke about. So I don't think I'm going to go through the entire history of AAPI, the civil rights history. I mean, I think for me, the issues that I feel most prescient and important to talk about are making the connections between the Quorum Novus cases and the continuing legacy of hostility against Asian Americans that are faced today. Just in November, I spoke on a panel with Judge Denny Chin, Professor Tom Lee, and they've established an Asian American center out at Fordham. And it was just a moment of reflection when you think about the cases such as, the issues such as internment. I hadn't really looked fully at the history to understand, for instance, that, with the bubonic plague, Asian Americans were also blamed for that. I think, for me, I'm a class of 2003 grad from Berkeley Law, so I consider myself a very young alumni. It's been 20 years, but I think that some of the issues that Erwin talked about, I would like to weave into the hate crimes that have been perpetrated more recently against Asian Americans. I'm a partner, an equity partner at a law firm. So, many of you who are thinking, wow, I have to make money. I want to do civil rights. And as I've always felt, it's possible to do both. It's really important to be a community lawyer, no matter where you are, to continue to do that work. I was very lucky to have been a paralegal community organizer at the Asian Law Caucus right after college, and that's where I met Dale and Dawn, and also Fred Korematsu, Karen Korematsu. And from there, I went to law school thinking I would do civil rights work. But, obviously, as a Vietnamese refugee, you're looking at my family's trust fund, right? So I needed to make some money and really just figure out what I wanted to do in my life. So I clerked and, I ended up in private practice. Fast forward, a number of years, and I represent some public companies in their high stakes litigation, but I've always been active in the community and on the board of FABA. And, if you fast forward to about 2020, many of us were sitting at home, obviously horrified with what was happening to Asian Americans, and then COVID, George Floyd, and so, those of us who are in the community, particularly the leaders of NAPAVA, including Don Liu, the GC of Target, as well as Wilson Chu, who's a partner at McDermott in Texas. They gathered up other law firm partners, Deb Yang, Ty Park, Brian Sun, and they said, let's form an organization and see which law firms would join, as well as corporate companies, public companies. And the idea was, let's make sure that if there are victims of crime, issues relating to AAPI hate crimes, that what we would do is make sure they have the best representation. They would get lawyers billing over $1,000 an hour representing them, and really being as tenacious as possible and using those resources to do so, right? And I think, in May 2021, my firm signed up right away. I'm in the Bay Area, so we signed up as a member of this organization called the Alliance for Asian Justice, now we're 501c3. May 2021, Wilson Chu calls me and says, hey, there's a victim of crime in San Francisco, Vietnamese. I'm not sure about his language capacity, but it turns out his English is perfect, our client. And he said, can you please talk to him, figure out what's going on in the Bay Area in terms of AAPI hate crimes. So from there, we met our now client on Lay. We spoke to the Miranda Kane, who many of you may know, representing the family of Grandpa Vika Ratnapakdi. We met with the lawyer Ramshi Liao, another victim of crime during that period, just to investigate what was going on. And from there, my law firm decided we weren't sure what we were going to do, but we were definitely going to take on this issue. And from the investigation, what we learned was that what was happening in San Francisco. And I called Dale right away. I mean, Dale's always in the mix. Don, Dale, and I always say, you should make trouble, good trouble. It's a real, it's really critical to do so. And so what we ended up seeing, and I just wanted to talk a little bit about the lawsuit, and I'm going to pass it on to Professor Yamamoto. In our lawsuit particularly, and just to connect it to sort of what, the last panel talked about, we're lawyers. I brought together a legal team from my law firm. James Unger, an associate, Juan Tran, who's another Vietnamese partner, Greg Scott, who was a former United States Attorney in the Eastern District of California, as well as the former district attorney. We said, why are these cases not being pursued? What is going on with our client's case? He didn't even know that his case had been resolved. And he said, I don't know if I want the defendants punished, but I certainly wanted to know and be a part of that. And so what we saw was that, the victims of crime, they were saying things from the then DA of San Francisco, they weren't being heard. So it was from there that we filed a lawsuit based on Marcy's law, which guarantees victims of crime the right to know about their cases, to go to court, let the judge hear, to have a voice in the process. And we filed a lawsuit in January of 2022, around this time last year, under the 14th Amendment, Equal Protection Clause, Due Process Clause, and also in the now Section 3, challenging the DA's policies for not, treating Asian American victims of crime equally insofar as Marcy's law. And we felt, I brought together probably 20 federal law clerks, Supreme Court, District Court, appellate, from my law firm, as well as working with, Deb Gaines' firm, Gibson Dunn, Ty Park, Quinn Emanuel, Brian Sun, and they all looked at the complaint as well as Dale and Dawn. And we said, we're going to file this to make sure that our DA is held accountable. We spoke to him first, and if he didn't agree with our views. And from there, we decided that that would open the door to conversation. It was really important to file that lawsuit, we thought, so that AAPI victims of crime would have their voices heard, but also to have district attorneys' offices across the country recognize that they had to treat these victims fairly, that these victims of crime had their cases had to be heard. They needed to know what was happening with those cases. And then from there, I sought a lot of advice from mentors in the community like Dale, Don, and others, and we ended up thinking we would have to defend against a motion to dismiss, discovery. We ended up having a conversation with then DA Chase Boudin and decided to withdraw the complaint without prejudice to start conversations. That complaint led to substantive conversations that really we thought would affect victims of crime positively in terms of language rights, in terms of making sure there was more mental health services. And so those conversations happened last summer. Due to the recall, we then had another DA. But I can, thankfully report that since that lawsuit, there have been a lot of conversations with the current DA of San Francisco, City Attorney Chu, as well as the mayor, as well as the police chief. And this Thursday, in part because of the lawsuit and other conversations that were had, there is now an initiative in San Francisco that focuses particularly on some of the issues that were complained of in terms of language access and all those issues. And so I think for me, the 2 points that I wanted to talk about was, the continuing hostilities faced by APIs unfortunately persist. APIs continue to be scapegoats. And I think the second thing that I wanted to comment on, and then I'll pass it on, and there's a lot of, I think, commonalities between the issues that we're talking about, is the role of the lawyer, to be a tenacious lawyer, to be a community lawyer, and to recognize that even if you're working in corporate America, it is obvious that you can use your resources and your education towards the causes that will allow for greater parity. And with that, on to Professor Yamamoto.
I'm going to speak from the podium. I teach classes of about 100 law students, and I feel much more comfortable moving around and standing up. Out to AJ and to Heidi and to the law journal staff. I published 6 articles with you folks, and actually have one more, so I'd like to talk to you after. And to Lori, organizing this whole thing. And I want to keep my hello to Bob Rusty, who's here with us in spirit. So Dean Chemerinsky addressed pretty much the question of why teach Korematsu, why it's relevant today. I'm going to do the flip side. Why teach and learn the Korematsu cases? So I've got a couple of responses, and here's my first. The horrible state secrets privilege. Sounds boring, anything but. In terms of real world impact and impact on national security, civil liberties litigation. Yet it's flying under the radar. So give me a couple minutes here. The state secrets privilege encourages government to exaggerate or even lie about national security to justify civil liberties abuse. It compels judges to allow government to hide from the courts and the public evidence of even egregious abuses simply by labeling them secrets. The Korematsu cases reveal what's at stake when the government is able to hide its grave national security transgressions. Real damage to communities, the checks and balances of American democracy. So let's glimpse at the Supreme Court's 2022 Zubaydah versus U.S. decision. See how this is startling this really is. Quick facts. Abu Zubaydah remains a U.S. detainee for an honorable. He was the first post 9/11 detainee recorded into a CIA black site for enhanced interrogation. The European Court of Human Rights announced that Zubaydah was tortured by the CIA in Poland in 2002. 80 electroshocks, 80 times waterboarding, etc. The U.S. government conceded that the torture produced no information to continue doing it. 2010, in federal court, Zubaydah's lawyers sought to depose the 2 CIA contractors who designed the torture program and carried out the torture. To gather under oath details of Zubaydah's torture for Polish prosecution. The U.S. intervened in a federal court action to stop the discovery, asserting state secrets privilege prevented identification of the host country, Poland. Well, the Ninth Circuit, when it got there, just shrugged. Everyone knows it was Poland. There's no state secrecy. And besides, Zubaydah's lawyers stipulated they only need this testimony of American contractors to get the details of the torture on the record. Justice Breyer's 72 majority decision expanded the state secrets privilege and blocked testimony by the U.S. contractors, despite the absence of any state secret. It tossed Zubaydah's entire discovery application. And it also precluded Zubaydah from securing any torture testimony from the U.S. contractors. The bottom line, the government deployed and the court approved the state secrets privilege to shroud from view under oath evidence of his torture by the U.S. That was the real aim. Keep it out of the formal public eye, out of the court record. Now here's where it gets interesting. In a very unusual pairing, so Justice Sotomayor and Justice Gorsuch dissented, and they uplifted Korematsu and the government's blatant misconduct there in hiding key evidence from the court and presenting a deliberately falsified national security claim. Their scorching dissent, in effect, deployed the revelations of the Korematsu litigation as a stark lesson about the executive branch's intolerable abuses, and that's Gorsuch's language, intolerable abuses against vulnerable groups during times of distress. When officials dissemble about national security for political reasons, such as the Trump versus White Muslim ban that Dean Chemerinsky talked about, and where the court, then exhibiting blind deference to the president, refused to compel the government to prove its national security justification. So here's the extraordinary Gorsuch-Sotomayor language, framing the light of still to be absorbed lessons of Korematsu. Gorsuch. The Constitution did not create a president in the king's image, but envisioned an executive regularly checked and balanced with other authorities. Our founders knew from hard experience the intolerable abuses that flow from unchecked presidential power. Recent history reveals that executive officials can sometimes be tempted to misuse claims of national security to shroud major abuses from public view. Korematsu, the president persuaded the court to permit the forced internment of Japanese Americans during World War II by relying on a key military report, we've already talked about, Dale talked about, that contained information executive officials knew to be false at the time. Yet it took decades for the government to publicly acknowledge its misrepresentations to this report. But clearly, Gorsuch was relying upon the revelations of the court. After Zubeda, the government now doesn't need to show a national security risk. The government just has to say, stay secret, and it wins. Civil liberties claims are shut down at the starting date. No government accountability for even egregious transgressions. No judicial reckoning for officials who allow it to happen again to anyone. Replaying of 1944 Korematsu, Trump versus Hawaii in 2018. This all enlightens Justice Jackson's ringing loaded weapon warning this Korematsu dissent that Lori put on influence. That the majority's blindness to reality stands for future cases as a loaded weapon ready for the hand of any authority that can come forward as a plausible, even if exaggerated or falsified claim of virtue. The 1944 Korematsu and the Korematsu Hirabayashi Yasui Korematsu cases illuminate what's at stake. The great damage to people, communities, and our constitutional democracy. When high officials are enabled to baldly dissemble on national security with judicial impunity. I'll continue with the second related story in a moment.
Thank you, Professor Yamamoto. Could you please give us the time frame under which Zubeda was unfolding?
Zubeda was from, actions occurred in 2002, 2003. The litigation, I'm used to talking without a mic to the class. The litigation. The litigation itself in federal court started in 2010. The opinion finally was by the Supreme Court in 2022.
So this is all very recent.
This is all very happening this year.
And so Korematsu is still very relevant today. And so given that, if I could turn to Dean Chemerinsky, if you could please give us a very, very brief lesson on constitutional law, we would appreciate it. And if you would also answer the question, what happens when the Supreme Court or just courts in general gets things wrong?
They do that a lot, recently. First, I think it's so important that we teach Korematsu because of its historic significance. This was the United States government putting 120,000 people behind barbed wire, what President Franklin Roosevelt called concentration camps, solely on the basis of race. When I teach the case, I point out to the students, it's written by Justice Hugo Black, we think of as a civil libertarian, in which we included William Douglas, we think of as liberal justice in history. It's the first time the Supreme Court ever used the language of suspect classification and implied strict scrutiny. And yet what they did was the antithesis of that. There was no showing by the government that there was a compelling need, let alone that this was necessary. And I think that the second, it's so important for students to realize that Korematsu has not been overruled. In Trump versus Hawaii, Chief Justice Roberts says, oh, Korematsu has been overruled. Besides that just being dicta, Trump versus Hawaii makes the exact same mistake as Korematsu. As to the state secrets case that President Yamamoto was talking about. Students need to see that. And finally, to answer your latter question, if there's anything I want my students to see for the first day of class, is just because the Supreme Court says it doesn't mean it's right. And they have to think for themselves and evaluate the decisions. And when the Supreme Court is wrong, it's so important for our society to loudly say it's wrong. The only way in which we can get the court to change When the society doesn't repeat the errors, if the voices in academia and the public to be loud and say, the Supreme Court made a mistake and it can't be followed, it can't be allowed to stand.
Thank you, Commissioner. And so I think it speaks to the importance of political lawyering and then also restorative and reparative justice. And so Professor Yamamoto, if we could turn to you, and if you could talk to us a bit about the importance of reopening cases to help bring about justice. We would appreciate that.
Thank you again, Heidi. And I'll build upon the comments of each and Heidi's question or thought about reparative justice and how do we begin to, why do we study the Korematsu notice cases and how does that reflect upon the importance of reparative justice? So if you bear with me again, I'm going to take a little bit more time this time, I'll shorten at the end to tell you a second story. And it's a story about the international reach and human rights dimensions of the Korematsu litigation. And it's a story that's startling and it's never told. And if you've heard about it, let's see, raise your hand anywhere along the way. But you're going to see how significant the Korematsu cases are in this story. Quick background. It involves the beautiful South Korean island of Jeju. Scorched with violence during supposed peacetime between World War II and the Korean War. Amid rising tension between the US and Russia. Widespread indiscriminate violence against thousands of ordinary villagers. Euphemistically and wrongly called an incident suppressing a communist rebellion. The Jeju April 3rd, 4.3, April 3rd tragedy was initiated by the US military government governing South Korea. Directed and then overseen by US military leaders. South Korean forces killed 30,000 island villagers, sexually assaulted, tortured tens of thousands of others. Only a few admitted resisting police abuse and protesting extortionist starvation policy. Innocent island villagers just wiped out. Thousands of village homes destroyed, entire villages burned down. All falsely justified then and for decades by the known mischaracterization of Jeju as an island of rents. Followed by harsh truth suppression for decades. People talked about it, tried to write about it, were imprisoned and tortured, so no one knew. The trauma and the material damage persist today. Amid this 4.3 violence, South Korean military tribunals summarily convicted 2,500 residents en masse, 100 at a time without charges or trial, leading to executions and imprisonment up to 15 years of hard labor on false charges of rebellion. Children and grandchildren, convicted survivors, later blocked from government jobs, universities. Fast forward 70 years. 18 of those survivors convicted then petitioned the Jeju court to remove the groundless state of disloyalty from their families and neighbors. Their petitions formed an integral part of South Korea's started, stalled, rejuvenated 20-year reconciliation initiative to deal with the tragedies of wounds. Judge Chang, Jeju Court, asked Professor Chang Ho of Jeju National University, an advocate for the petitioners, to help identify international precedents for reopening mass incarceration cases decided later as a part of a reparative justice initiative. Judge Chang asked Professor Ko, in his words, to submit to the court similar world cases for reference to the retrial of the Jeju 4.3 providers, because this court thus far has failed to find meaningful world cases to compare. He didn't know how to go forward with this kind of request 7 years after the fact. So Professor Ko asked me for permission to translate and submit 3 chapters of my 2013 book, Law of the Japanese American Internment. And those chapters detail the successful Korematsu, Hirabayashi, Yasui, notice petitions filed in U.S. courts ultimately contributed to the 1988 Civil Liberties Act Apology and Reparation. Part of the judge wanted to know is how is it that a major country like the United States could be called to account and called to account through the court system. And I was asked to contribute in this way because I made several trips to Jeju over the preceding 7 years to work with the survivors, advocates, journalists, educators, on how to bring the US to the 4.3 justice table. Because the US had continued to deny any responsibility. So Professor Cole submitted the translated account of the Cornelius case to the Jeju Court 2018 to enable the petitioner's lawyers, again in his words, to argue to the judge the relevance of the Korematsu Cornelius case based on its comparison with the cases in the Jeju Court. Similar to the Cornelius litigation, the Jeju petitioners 2018 more broadly sought to vindicate all wrongfully convicted villagers and garner first-time judicial recognition of the sweeping 4.3 tragedy. You can feel the resonance of the Cornelius cases. After hearing the survivors' live testimony, Judge Chang ordered retrials to ascertain whether the military tribunals then acted as mere kangaroo courts. For the first time in 7 decades, with the entire Korean nation watching, the survivors spoke their suffering in open court. Judge Chang found the petitioners, in his words, were incarcerated and suffered harsh treatment, such as physical abuse and torture. Their testimony was candid and natural, with no sense of embellishment or exaggeration. These trials are so important because it gives voice to the people who have suffered. It gives them a chance to really speak their suffering to the public as well as to the courts. 2018, the trials took a surprising turn. In closing, the prosecutor hoped that instead of new convictions, the retrials would help heal the wounds of the survivors and of Korean society itself, restorative justice. In his words, prosecutor's words, by sharing in some small way the bitter suffering of these people, and the suffering of history and the Korean nation, and to bring the truth of what happened then to light now. The importance of being in court, because then there's a formal record and everyone is watching and listening. Much like Judge Schroeder's and Judge Patel's Cornelius decisions, a rare intersecting moment of law and history. That's what this is about. 2019, Judge Chang swept away 70 years of 4.3 injustice. He expunged the petitioner's criminal records, a landmark human rights movement. And his court effectively cleared the names of all 2,500 villagers abusively convicted en masse. One surviving petitioner spoke for all. For decades, we survivors and families lived ostracized, second-class citizens, untouchables. I endured a life in prison without the kind of trial we saw today that left me with bitterness in my heart. But now I have been acquitted. The stigma has been erased from my names. Amazingly, the story continues, but only for another minute. Judge Chang awarded the 18 surviving petitioners reparative damages, totaling multiple millions of dollars. More came out of the works of filed petitions, more cleared records, more reparations. But still, there are many more who haven't received reparations. But then the Korean military stepped forward, those most directly responsible are the police, and they offered their first ever abject apologies to the families. It was what we call a chicken skin moment. I'm getting it right now. The first time these people, they said it's heard an apology from those responsible, except for the US. Then it continues after 20 years of Jeju community grassroots advocacy, political lobbying, scholarly assistance, and I can say I had a small piece of that. Just 1 year ago, 70 years after the fact, the Korean National Assembly finally authorized substantial reparations to thousands of designated victims and family members of the tragedy. Reparations landmark, pretty much worldwide, triggered by the retrials, essentially patterned after the Cornelius. So this spotlights a second reason for teaching, learning the Cornelius cases. To reopen historic cases to illuminate specific suffering of the people involved, but also to illuminate the larger injustice and the need for present-day reparation. It's in the past, but there's a need for present-day reparation. To bring a measure of social healing to the communities and the people, but also to society itself, which is suffering itself. to end the transgenerational economy, which continues unless there is relief, and to push government institutions to prevent it, this kind of tragedy, from happening again to anyone. Because for the students, especially, the quest is first to prevent human rights injustice. But then when injustice occurs, even years later, step up and help acknowledge the transgressions and repair the present day damage to communities and to democracy itself.
Thank you, Professor Yamamoto. Well, as you mentioned, this case is not only legally important, it was very important to the community of the survivors. And so if we could turn the conversation back to Quinn, if you could talk about the case that you brought against the SFDA's office and what that actually meant to the Asian American community here in the Bay Area.
Sure, I'll talk about that briefly and then also talk about restorative justice, just because it's sort of the same theme and reparative justice, etc. So I spoke about the federal court case to just rewind a bit, and I've spoken to Erwin Chemerinsky about this too. The real sort of tension when we were bringing our lawsuit related to API hate crimes is that there felt like, you know, some people in the community felt like there was a tension. Are Asian Americans then taking on or, you know, really trying to challenge restorative justice? And that's something that I've been thinking about for a long time, and, you know, in our case particularly, and in the cases of Grandpa Vika, as well as Mr. Wang Liao, the defendants are people of color, young, youthful, and, you know, the folks on the other side, and I don't even want to say the other side, but it was a question of how do we do this such that the Asian American community could feel protected. At the same time, many of us who are progressive also don't, you know, believe in mass incarceration. We know that our prison systems, criminal justice system, needs a lot of repairing. And so I think that was a struggle for the, you know, and it remains a struggle for the Alliance for Asian American Justice. And so, you know, to take a step back, before we even filed our federal lawsuit, we talked to our victim, and I think it's always important that if you have a client, that is, you know, it's the community is at the heart, I think, of the federal suit. And then we did an individual lawsuit in state court, got filed before Judge Sam Thang. And we didn't ask for any money or anything. The client really just wanted an apology. And we, you know, we filed the lawsuit. It was very difficult to find the defendants, but we have. So stay tuned. I think they're willing to mediate. I can tell you that much. It remains really important to our client to know that there is humanity on the other side. Us too. There were children involved. There was a whole family who, frankly, you know, they have their own different circumstances. I think for us, we're still, you know, processing this case. We filed both over a year ago, but I think for us in the Asian American community, we want to make sure that we are protecting victims' rights. And on the other hand, too, you know, there are a lot of complex issues happening racially as well, and so we're working through the civil rights community and talking to various of our friends like Dale and others on how to negotiate that. And I think that's something that we've been challenging the DA's offices across the country. How do you at the same time protect, you know, API victims? You know, there's government accountability on one side, and on the other side, you have restorative justice issues where you want to make sure that you know, criminal defendants are being treated fairly. So I think it's something that right now with our lawsuit we're grappling with, but it is something that the Alliance for Asian American Justice believes in both, you know, both of these issues. And so I wanted to, you know, turn my, I guess now to prepare the reparations issue.
Yes, wonderful, thank you, and we will definitely stay tuned. And now on to Dean Chemerinsky, let's maybe talk about a story that has concluded in terms of reparations and what it means for the Black community in Los Angeles County.
Sure. And I think it's important to think about what are reparations to be achieved. To some extent, it's about compensating injured people, but the reality is there's never enough money to really compensate. When you deal with the kind of injuries involved, no amount of money would be enough. I think it's about a government apology for its wrongdoing. I think the government acknowledging what it did horrible does lead to the kind of social healing that Eric was talking about, and it can help with regard to transgenerational injuries. Also, when the government has publicly admitted it's wrong, that makes it less likely the government will do it again in the future. With regard to the Japanese internment, you know that the Civil Liberties Act of 1988 was passed, signed by President Reagan, and provided $20,000 to each of the living individuals that returned during World War II. $20,000 is a pittance, but it was important that the government extend this apology. It was important that the government also take the step of saying what we did was wrong. We could talk about what not just last year, and maybe within my question. This was with regard to Bruce's speech. This was a beach owned by a Black couple in Manhattan Beach, California. It was a community that was 99% white. It was a beach really for Black individuals at the time. And the government, going back now to 1924, used its eminent domain power to seize this property from the Bruce family. And just in 2021, Governor Newsom signed a bill, SB 796, that was meant to restore ownership of this property to the Bruce family. So that's a form of reparations. And your question also alludes to, there was recently, and still an ongoing discussion, condition here in California, with regard to reparations, those who suffered as a result of slavery. And there's a fascinating discussion. Should reparations go to all who are of African descent because all have suffered the badges and incidents of slavery, or should it be just for those who can prove that they're descendants of slaves? And I had the pleasure of testifying before the Reparations Commission, and I said, the goal has to be something that can be upheld in the courts. And I think if it is entirely race-based, this Supreme Court will not uphold it. This court has made very clear that anything that's race-based is likely to be struck down, not likely to be strict scrutiny. And so it's much more likely upheld if reparations is for those who could prove lineage, the descendants of slaves. I realize that doesn't compensate all who suffered slavery. It's very difficult to prove, but it's also, I thought, important if there's going to be reparations to not have it struck down by the Supreme Court.
Thank you, Dean Chemerinsky. And now I think to close out our panel, I'm going to ask one final question, and that is if you could give one lesson to the young, aspiring lawyers in the room in terms of political lawyering or in terms of reparations and restorative justice, what one piece of advice would you give us? And we'll start with Professor Yamamoto and work our way toward Dean Chemerinsky.
Sit down, please. There's so many pieces to that response, but the main one I think is I learned from Del Minami when I was his law clerk way back then. Just left a law office and he was training young lawyers before I became a member of programs. I was a law student. And that's partly when you engage in a justice struggle, it's really important to approach it in two ways. One is to engage with the people and to know what their real struggles are, what their real stories are. So you don't fight it in the abstract, and you don't fight it based on what you think is important, but it's got to grow organically from what's important to the people. And the second is to look at law not as a neutral, objective thing that's to be found in law books, even though I teach from law books. But law is political, at least in controversial cases. And you need to have a political analysis and a political lens to evaluate what's happening on the ground, to evaluate how courts are going to respond. As our prior panel talked about, and I think Rod talked about, it matters who the judges are. And it matters who's on the panel. And that is how you do your strategy. And so you've got to combine those two things as you begin to take up justice to prevent it from happening. But if it happens, then how do you repair the damage resulting from it? got more to say to Sue, but I'll come back. Maybe later.
Thank you, Professor Evermeyer. Lynn?
So,
Similarly, I have a few thoughts. First, I clerked for Judge late Larry Carlton, East Cal, Carter appointee, and he always said cases, not files. These are people's lives at stake. Any case is just as important to me, whether it's Social Security, disability appeals, whether it's a corporate case, it's always about the people at the end of the day. And that's always stayed with me, particularly as a federal clerk. I think that resonates with me, and there's always the ability to find humanity and empathy in everything you do. I think the second lesson I learned is that you can impact and affect social change in whatever environment you're in. I think, people think, oh my goodness, I'm going to a law firm and now I'm going to make money and be a corporate show. That's absolutely not true. I mean, I think a few things that I've learned is, for instance, at my first law firm, very progressive firm, went there, I was the only woman of color lawyer. It is quite isolating to be you sometimes and to have to envision what that success might look like for you when no one else is like you. And then when you go to court and you're mistaken for the court reporter, you're mistaken for the client, paralegal, the associate, you name it, right? I mean, in 2017, I tell this one story. I was defending a $100 million consumer class action. Counsel, Los Angeles Superior Court. I was in the elevator, pressed a button, and the person says, complex? And I said, yes, complex. And then he said, are you a court reporter? It's like 2017, I was ready to partner. And then I said, oh, I didn't ask that. And he said, because you're blessed. And I said, it's because I have a lot of binders of arguing summary judgments today. Got out of court and thought, wow, life in America. Then I went and my case got transferred from Judge Yui girl. We were winning. He let us file so many dispositive motions. Anyone that came up, it was like, Ms. Top, another dispositive motion? Yes. Summary judgment was coming up, and then we, for whatever reason, we got reassigned. New judge came in, and I was ready for summary judgment, but I knew she wasn't ready for us. And the first thing she said to me, and then another woman, lawyer, my partner, where's your lead counsel? Where's John Pecker? And in that moment, I said, John Pecker's in his office in San Francisco. I'm your lead counsel. I'm your lead counsel. It was those types of incidents happen repeatedly. So I think, for us, it's really important that as lawyers, we talk about social justice, you can make a difference just by being excellent. There's a lot of people that support you. Keep at it, right? I mean, for me to make partner, that was something that I didn't even know was achievable. I'm like the last sort of candidate who would think to be an animal acting partner. But I think you can impact change in your law firm. You can use those resources to open doors for others behind you. And then you can bring lawsuits. I mean, I've been able to bring so many civil rights lawsuits. Dale's laughing, but it's true. I always say, we spent $1 million in pro bono fees on these Asian American hate crimes, but it was so worth it. And my law firm supported it, and I think, you have to go to a place that supports it. But I think what I would say is no matter where you go, you can impact change and you can find others who are like you.
Thank you, Quinn. That is very, very inspiring. I thought it was very perspective and so like being confidence. And so finally, we will turn to Dean Chemerinsky, if you could give one piece of advice to all of us.
I agree with you've already heard Eric and Tim, but mine would be real simple. To fight for justice, that you can make a difference. The story of the Korematsu case you've heard today is how much by fighting for justice, those lawyers made a difference. You can make a difference for people's lives, the most important, the most intimate aspects of their very existence. I'm not naive. I know you might lose. The last case I argued in the Supreme Court, I lost by the close margin of 9-0. But if you don't try, you have no chance of winning. And even if you lose, it might be that case for that day, but you're fighting a longer term fight that over time will succeed. And there will be instances where we really make a difference. And ultimately, each of us wants to feel good about what we're doing in our time on this earth. And so long as you're fighting for justice, whether you win or lose, it's something you can feel good about.
Also, probably going, for us to, let's all get going. But before we do that, I'm gonna turn it back to our audience for Q&A. I already have one hand, so if someone could hand that person a microphone, or if you wouldn't mind standing up and speaking.
Folks,
Yes.
so I wanted to ask about the quorum nobis cases in the United States. So a two-part question. Can and how should we expect quorum nobis cases for communities and prisoners held in prisons, military courts, etc., in the United States, for example, Guantanamo, right? So folks are alleged as national security on the basis of race and ethnicity. It appears to me that there would be some kind of quorum nobis analogy, what might be expected on the horizon legally. Then, second part of the question, Dale's words were smoking gun for the quorum nobis cases was new evidence, right? More evidence coming into daylight. What kinds of legislation or legal precedent would create a universe of daylight when government actors, officials have contaminated evidence for a variety of national security allegations?
Okay, well, I'll take the first question. What about quorum nobis actions in present day America? And the answer is quorum nobis has proliferated from as far as Hawaii to West Virginia, and I kind of track like in contact. It's using criminal cases to reopen criminal cases where the sentence has been served. That distinguishes it from bills of habeas corpus when the defendant is still incarcerated. There's a civil proceeding with discovery now, Korematsu established that. So it can be used and is being used. But again, it's really important to know that the way the quorum nobis petition was framed in Korematsu and Hirabayashi Yasui was that there has to be continuing harm, perhaps not just to the individual, but to all the other people like that individual or that individual's community. So-called continuing prejudice. So it's extraordinary writ. It's very important. So if you're going to do that, first of all, the defendant is no longer in custody, but is suffering the stigma for himself or herself and for the community. So you have to show those things. If you can do that, then quorum nobis becomes a viable mechanism, and it'll stop there.
Of course, quorum nobis becomes a way of challenging a conviction. For those in Guantanamo, none of them have been convicted. I think that what's important is focusing on those who we know have been wrongfully convicted. And we don't have adequate statutes, federal or state, to provide redress for those who were wrongfully convicted on the basis of prosecutorial or police misconduct. And that's a place where I think legislation could make a difference.
Can I add to that really insightful point earlier and your question, The Jeju court that awarded reparations was based on a statute that South Korea has that says when someone has been wrongly convicted in a serious kind of misconduct, then they're entitled to forms of damage and reparations. So that is a very viable, and you might look to South Korea as a potential model.
Thank you, panelists. Everyone, please join me in thanking our panelists for the opportunity to come in. Thank you very much. And last, but certainly not least, we have Dr. Karen Korematsu joining us to give closing remarks. Dr. Korematsu is the daughter of the late civil rights icon Fred Korematsu. Since her father's passing in 2005, Dr. Korematsu has carried on his legacy as a public speaker, educator, and civil rights advocate. In 2009, she established the Fred T. Korematsu Institute to advance racial equity, social justice, and human rights for all. She works tirelessly to expand civil education across the country, inspiring and promoting the Fred Korematsu Day of Civil Liberties and Constitution every January 20th. In 2015, Dr. Korematsu became the first non-lawyer to be inducted into the National Asian Pacific American Bar Association. She serves on the board of directors of Advancing Justice, AAJC, and the Nakaba Law Foundation. Please join me in welcoming Dr. Korematsu.
Thank you for that kind introduction, and I've been told I got 5 minutes because the first panel ran over. Are we not surprised? Well, I want to thank Berkeley Law and the Asian American Law Journal for creating this program today for the 40th anniversary of the Quorum Novus cases. It's really difficult for me to believe that it's 40 years because I remember sitting in my parents' living room and meeting the Quorum Novus team, some of the members for the first time. And I was very suspicious because I said to them, well, what's in it for you? Because I learned this term called pro bono. Well, I've never heard that before. And they were going to, work on my father's Supreme Court case free of charge. And also there was Gordon Mintz coming up as well. And I think it was Don Tamaki that said, well, we would pay to even work on this case. But I still was very suspicious because they were younger then and a little naive. But what I want to say also is that it took courage. I believe it took courage for many, for first Mr. Bessick to take on my father's original Supreme Court case, or at least visit him in the San Francisco jail to ask him if he would be willing to fight his case, because Mr. Bessick, who was then the executive director of the Northern California affiliate of the ACLU, thought it was unconstitutional, and he was threatened with ouster from National. Everyone at that time, was supporting President Roosevelt, and Roger Baldwin, who was the president of the ACLU, was friends with Roosevelt. Just like we did after 9/11 when we were supporting President Bush, because that's what we do as Americans, we come together. But it also was a risk for my father to reopen up this Supreme Court case, because when in 1942, he was vilified and ousted from his own Japanese American community for taking a stand. And even again, as I think was mentioned in 1983, because of redress and reparations, people said to my father, well, Fred, if you reopen up your case, and you lose, you're going to hurt our chances for redress and reparation. But my father really felt like the government was wrong. And when I asked him when I was 16 years old, that's what he said. The government was wrong and he was right. And he believed that all those years, and until 1983, until we met the Quorum Novus team and Professor Irons, who couldn't be here today, did I learn that my father never gave up hope that someday he would be able to reopen up a Supreme Court case. He just didn't know how to do that because lawyers are expensive. But that's, to me, that tells me a lot about how he never gave up hope. And he was never bitter or angry or blamed anyone. It was just simply that he was an American. And when his draft card was changed to become any enemy and alien, that really hurt him. When he tried to enlist in the armed services and was denied because he had a Japanese name, even though he was born in Oakland, California, that really hurt him. having the discrimination he faced as a young man for not being able to get a haircut in San Leandro, you know, right down the road here, because he was Japanese American or to be served in a diner. It's those kinds of racist experiences that you can decide whether you want to be angry and to do something that's going to be dangerous or illegal, or you can take a stand and make those decisions that's going to make a difference. And that's what he wanted to do. He not only wanted to reopen up his Supreme Court case, of course, to vindicate himself, but so that something like the Japanese American incarceration wouldn't happen again. And I know that that's what Gordon and then also felt. So I would be remiss though if I didn't mention kind of my two cohorts that we were involved in advocating for our fathers. Holly Yasui, who unfortunately passed away a year or so ago because of COVID, and Jay Hirabayashi, who lives up in Canada. And we would be on panels together to talk about our experiences and as the kind of the bookends, to our father's story. But, we also know that it took courage for the Quorum Novus teams to keep on fighting. And even I want to recognize Judge Schroeder and Judge Patel, because also that takes courage to make those kinds of decisions when you're on the courts. So it's, and the other thing I just want to mention is that when we had the Quorum Novus teams working with my parents, for all you young attorneys, the Quorum Novus teams treated my parents like they were paying clients. They brought them in for discussions, let them know what was going on, ask them questions, let my parents ask questions. Ben and Gordon would ask questions of their teams. And, that's important about learning respect. Just because you're the attorney, you don't know it all. And to listen to your clients, because as someone mentioned before, it is about them. It's about the people that are in these cases. That's why my father spoke here at UC Berkeley. That's why I speak across this country as well. Because these are real lives that are impacted, and we all can make a difference, because this is about all of us. So as you leave here, remember my father's words. Stand up for what is right, and don't be afraid to speak out.
So thank you, Dr. Korematsu. If you'd like to take some with you on the way out, you're more than welcome. And with that, I'm going to turn it to our fearless leader, AJ.
Hello again. Thank you, Dr. Karen Korematsu, and thank you to all of our panelists again. If you could give them another round of applause, please. So with that, we have come to the conclusion of our symposium. I would like to thank the audience for being here and for bearing with us as we went over time. And lastly, I would really like to thank Lorraine Benai, without whom none of this would have been possible. She has walked me through almost every step of the way. Please give a applause to Lorraine. And lastly, thank you to the ALP Symposium team. David Shen, Elisa Lee, Eunice Lee, Salas Kim, Elaine Lee, Gloria O, Heidi Kong, Jesse Rong, to our editors-in-chief, Diana and Kristen, and to Chelsea Hu and Julia Wang. Thank you, everybody, for making this possible today. Please take the